Today we're going to talk about 401k funds and some of the changes happening to the 401k withdrawals and how a qualified domestic order or relations order can be used in a divorce case. If you are involved with a relationship that has a spouse with a 401k, there are some restrictions on how that asset can be distributed among the parties. The 401k itself has some restrictions on assigning benefits to another person, and a qualified domestic relations order, or QDRO, is the means that's used when a relationship is being dissolved in order to distribute those assets. And some of the new laws that are hitting the books in 2022 might make that more of an important type of process to consider. And the reason why is because there's a bill that's being proposed, and it'll probably pass the legislature, where the required age for withdrawing from 401ks is going to be raised from 70.5 to 72. In fact, they might even raise it again to 75, meaning that you don't have to start taking money out of your 401k until later in life. That's what the law is intending to do. So why is that important? How is that going to affect the QDRO process? Well, if more people are keeping their money in 401k funds longer, it's more likely that those funds or those relationships may be subject to a divorce. And if there's more of those happening, it's going to be necessary to have a proper distribution of those assets to both parties in the relationship. Just to give you an idea of the scale, 401k plans are the largest of all direct contribution retirement plans. So there's different kinds of plans. There's IRA, 401k, KEO accounts, retirement accounts. 401k represents 70%. So if you're in a relationship and your partner has a retirement account, it's likely to be a 401k. A third of the people with 401ks are younger than 40, meaning that there's a lot of years to build up these assets and appreciate the value. So we're going to look at how that's handled when there is a dissolution of the marriage, and even give you an example of how the form is created to distribute those assets. And here's an example of that form. This is a sample from one particular county, one particular provider, and we'll go through it to use as a template. Now remember, we're not attorneys, we're not giving you legal advice, we're just giving you suggestions of topics of conversation with a proper legal provider or provider of these services. So let's suppose that you are in a relationship, in a marriage with a partner, and part of the assets of that marriage include a 401k retirement account. That's going to be very common. A lot of people have that from their employer. So now the assets are being distributed because of a dissolution of the marriage. So if there's a bank account, you split it in half. There's equity in a house, you split it in half, vehicles, whatever. But a 401k fund, the retirement account, has very specific language in it that says you cannot assign benefits from that 401k to a third party. The reason why that's baked into the requirements of a 401k is to make sure that the person who is accumulating these assets will get the benefit of them in retirement. The whole purpose of a 401k is to protect the financial security of the account holder in retirement. So they wanted to protect people from signing away their rights or selling their rights or otherwise encumbering their rights to a 401k. So they made part of the law, look, if you want these tax benefits from a 401k account, you have to agree that you're not going to assign these away. It's what's called anti-assignment alienation rules to ensure that the participants' retirement are actually available to provide benefits during retirement. However, there is an exception, the QDRO exception, which is a domestic relations order. You can assign some or all of the retirement benefits to a spouse, former spouse, child, or another dependent. So these can be used for spousal benefits, child support, other type of assignments. However, it only will distribute those and give you that exception if it's a qualified domestic order. And if it's qualified by the court and it's signed by the court, then it's delivered to the plan holder. The plan administrator will then determine if it's a proper QDRO and then execute it as ordered by the court. So the basics of a QDRO is it's a court judgment like any other judgment. It's a decree or order for a retirement plan to pay child support, alimony, marital property, other distribution to one of those parties we talked about, spouse, former spouse, child, that kind of thing. And it can break it down by different percentages. It doesn't have to be 50-50. It could be that one of the spouses gets all of the 401k, the other one gets all the bank accounts. It can be distributed however the dissolution of those assets is negotiated. The person who receives the benefits, whether it's the spouse or a child, also reports the payments received if they were a plan participant, meaning that if there's tax benefits for the reception of those payments, they still receive those tax benefits. If the person who receives those is given just a share of the benefit, they also benefit from the cost basis of those shares. So if the cost basis was, $10,000 and the current value is $100,000 and they got half of it, they also receive half of the cost basis. If the distribution is paid to a child or another dependent, it's taxed to the plan participant. There may be ways to roll this over into other types of accounts. The most important thing to remember is that alternate payee has to be designated by the court. What happens most of the time is the parties to the divorce will agree upon the distribution of these assets. One of their attorneys will create the decree or the order, presents it to the court, and the court signs it. The judge signs it. To be recognized by the plan, it has to be a qualified domestic relations order. It has to be a judgment by the court, has to be made pursuant to a state statute, domestic relations law, community property law. It has to relate to the provision of child support, alimony, or marital property distribution. It can't just be a gift. It can't be something other than part of that divorce settlement. The state court or another authorized party must actually issue the judgment to formally approve the property settlement. If that doesn't happen, the administrator of the plan can't accept it as a distribution. The parties to the divorce don't have to sign it, but the judge has to sign it. The plan administrator, whoever's holding the money, doesn't have to be part of the court procedure. They can petition in certain instances, but they don't have to be part of the court. It doesn't have to be issued by a state court. It could be any other judicial body that has authority to give these kind of decrees. So the big thing is making sure that it qualifies, because if it doesn't qualify as a QDRO, qualified domestic relations order, the plan administrator does not have to abide by it. So make sure you get good legal advice from an attorney to make sure that your decree qualifies so that the plan administrator will execute it properly. What has to be on the QDRO? Well, we'll look at the sample in a minute, but it has to have the name and address of the plan participant, the name of each plan to which the order applies to. So if there's a retirement plan with a name on it, or a plan title, retirement plan number 101, whatever it is, has to have identity of that plan and that account number. It has to have a dollar amount or a percentage of the plan to be applied to the alternate party, and the method of the payment. Is it a one-time lump sum? Is it over time? Is it at time of distribution, maybe later in life? So those all have to be on the order. The order, however, cannot require that the plan provider gives the participant another form of benefit that's not under the plan. So the order can't say to the plan provider, you have to give the benefit as another means other than what's already in the plan. You can't change the contract. It also can't require that it gives increased benefits. It has to use the existing contract of that plan and just apply it to a different person. Now, even though a QDRO is normally part of a divorce decree, it does not have to be part of a divorce decree. It could be part of a separation agreement. It could be part of some other arrangement between the parties for, let's say, child support, even if there's no marriage. So even though it's normally part of a divorce, the alternate payee does not have to be somebody who's getting a divorce from the plan beneficiary. The type of document that needs to be filed, here's an example of one, is like any other court petition. There's no form to fill out. There's no blank form with spaces to fill in information. You have to type up a petition. This is an example of a court petition. And you notice there is a format to it. There's a plaintiff and defendant, the name of the party. There's a syntax of the form with separations with these closed parentheses. This is the syntax of any other court filing that's used. Every court's going to be a little different. Some will have double space, some will be single space, some have to have capitals on the defendant, some will have different margins. Check with your court to see what their requirements are. And again, your attorney normally would do this, but you can also do it without the benefit of an attorney if you follow the procedures of your court, of your jurisdiction. And basically what it says is that the court has jurisdiction over the parties, and the petitioner and respondent have stipulated to enter this order, and then it says, now it is ordered that this participant with a date of birth, social security number, and address will give alternate payee date of birth, social security number, and address benefits from this plan. Has a name of the plan, the administrator, address, and it will say the division of the contribution, either by dollar amount or by percentage. The effect of this order as a QDRO recognizes the continued jurisdiction of the court, meaning that it's an exception to the 401k requirement that prohibits distribution to a third party. And then it gives the amount of the alternate payee's benefit, either a dollar amount or a percentage. Here's the percentage. And it tells you the date, form of payment, the alternate payee's rights and privileges. Make sure these don't violate the underlying plan. And it might have some other special clauses for limitations or other requirements for the parties. Again, make sure none of this violates the underlying plan benefit contract, because if it does, the plan administrator can reject it. Normally, whoever drafts this will have the right information, but it's up to you as a participant in this process to make sure that it conforms with the underlying plan. So a QDRO is an important procedure in the distribution of marital assets or marital estate. And having this part of a asset search is important to know what 401k funds exist, and then also having it be part of a proper, fair, and equitable settlement of a divorce or of other family law cases is going to make sure that the parties are accounted for properly and all of the assets are distributed either at the equitable order of a court or negotiated settlement by the two parties.